SJC-08998, Commonwealth versus James Norris.
Mr. Erickson, good morning still.
If it please the court, my name is David Erickson. I'm here on an appeal from a conviction of murder in the first degree. The case has also had two motions for a new trial, a motion for reconsideration. It was briefed in this court, and then it was remanded, and then an evidentiary hearing was held before the trial justice.
Could you keep your voice up or put the mic closer to you?
I'm sorry, Your Honor. This is a case with considerable history. It was, there were two motions for a new trial. There was a motion to reconsider. It was briefed in this court and it was remanded before argument. The matter came on. There was a full evidentiary hearing on the motion for a new trial. The trial judge issued a decision. I believe the standard was incorrect in her decision. I think the standard to be applied here was an error likely to have influenced the jury's conclusion. In essence, the claim is on ineffective assistance of counsel, and then the failure to preserve exculpatory evidence.
Before you go further, can you just clarify for me there's no affidavit from trial counsel, is that correct?
No, but he did testify during the evidentiary hearing on the motion for a new trial.
So he did testify?
He did testify.
What did he say?
There was a profound failure of memory on his part, especially given the fact that this was his first murder trial. The one thing that he did talk about was a dispute that he had with the defendant. There is a recorded statement by him which was made in a room beside the courtroom. It was during the trial, which dealt with the whether or not to call a witness, and he claims to have acquiesced in the defendant's requests, but he does not allow the defendant to speak during that statement he makes. He had some memory of that, but the actual reasons why he did or didn't do things he had no memory of. I think essentially the main point that I make is that the use of a criminalist in this case would have substantially benefited the defense, because it undermines sort of each point that the Commonwealth put forward.
And so were you able to use a criminalist in your motion for new trial?
I was. The family, Mr. Norris's family, throughout this proceeding was, I think it's worth noting, was supportive of him and did come up with the funds, although he has had appointed counsel all along. The judge, the trial court, was consistent in denying requests for funds. I called a criminalist. She's a professor from the University of Maine, and she testified to really each of the points that are set out in the brief. And I think the issue that if it had been before the jury, it likely would have changed the outcome, especially given the fact that this is a jury that returned with a question on reasonable doubt after hours of deliberation, and when re-instructed, then returned, I believe, about 35 minutes later, was that there was a photograph of the crime scene, and it's innocuous in and of itself until a criminalist, talks about it, because it shows a dresser and it shows a table, and the table has CDs and what would appear to be where a CD player was. When you look at the dresser, there are blood stains on it by the use of the chemicals that a criminalist uses that indicate that, and the doctor testified to this, that somebody with bare hands, because there's a partial fingerprint, was going through the dresser. The testimony and the government offered a very comprehensive story was that Mr. Norris was wearing gloves. And so he wouldn't have committed the murder, be wearing gloves and be going through the dresser, and leaving fingerprints.
He comes back, right? I mean, there's a lot of people moving about in the apartment after the murder, right?
There are a lot of...
Including him, right?
Well, the allegation is he's there, and that's one of the problems with...
The fact that he may be wearing gloves when the murder is committed doesn't mean he's wearing gloves throughout the cleanup, right?
Well,
Somebody's cleaning this up too, right, or trying to.
Respectfully, I don't think you use them during the murder and then you take them off when you're going through. But also the second part of what I was saying was that there's a blood smear by an electrical outlet indicating that the person goes through the dresser quickly, with bare hands, and then grabs the CD player, and the fair and reasonable inferences, and then takes off. And the Commonwealth's theory of the case is that Mr. Norris is there, for hours, and he's trying to clean the place up. And I think it's very powerful evidence.
Well, the place is open for hours because people try to call the police. They don't show up for how many hours? There's the phone calls made to the police after by...
Phone calls.
Yeah, go ahead.
Phone calls are made by two of the individuals who come over, and
then the police don't show up for how many hours after that?
well, the police do show up. They show up. They check the location, and one of these officers, testified during the evidentiary hearing on the motion for a new trial, and he does not see the blood on the doorstep. He doesn't see the evidence as the Commonwealth says it should be. He is not called during the trial of the case. Again, trial counsel has no explanation for this, and there's really there's no benefit to not calling him, and it also undermines the government, the Commonwealth view, this dovetails into the exculpatory evidence claim that there are two witnesses who testify. One is who's testifying under hoping to gain favor. He is under indictment in New York State, and the other is an individual who has a conversation with or supposedly has a conversation with Mr. Norris, very late in the evening of that day. And the judge found that originally one of the witnesses stated that Mr. Norris was not involved, but was vigorously questioned and eventually gave a statement inculpating Mr. Norris. I believe that the judge, in her motion for a new trial, the second ruling, indicates that only one of these statements was written, and the other one was not. But there are factual details that are set forth by the government in this case, as far as the comings and goings of these people, that all of this evidence contradicts. There was also a footprint. The footprint, it's pieced together from the evidence that was offered, but it is tied to the defendant because there's a footprint in a shoe print in snow found at a house associated with the defendant. Again, there was a failure of trial counsel to call an expert on this. This doctor did testify during the hearing that there were different dimensions to these footprints, and there were also weather records that indicated that probably snow had fallen in this area, and that snow or some change in the appearance would have occurred.
And the theory is that it was Brunel and Johnson who committed this crime, who killed him?
The theory offered by trial counsel was that it was Brunel and Johnson that committed this crime. I don't think that was the best way to go about this case. It was more to raise, the better approach was to raise reasonable doubt. There was an allegation, there was also statements that Chad, the victim...
You've got a problem because Brunel testifies that the defendant is, I can't remember the term he used, he's going to do the victim. And then Johnson observes the beating of the stabbing of the victim. So don't you need to discredit, don't you need to shift the blame to Brunel or Johnson? It seems like a pretty smart tactic.
Well, I think you can shift the blame. I don't think that the defense has to come up with to solve the crime, so to speak. But it's got to raise...
Got a lot of evidence here that you got to deal with, a huge amount. So you need an alternative theory, don't you? I mean, you don't need it, but to say that that's not a reasonable tactical decision seems to me pretty problematic.
I think years ago one could be kind of a seat-of-the-pants lawyer. I think the criticism that the defense is making to trial counsel is that he didn't look at the evidence, that he didn't analyze it. And he certainly can come up with a theory once he's done that. But I would suggest, Your Honor, that trial counsel didn't do that. And before you even get to that point of what's a reasonable theory, one has to look very carefully at all the evidence. I think nowadays, because of forensic evidence, and I've been sitting here this morning, it seems to come up, in every case. It has to, it has to be analyzed. It's, he puts Norris at the scene in both his opening and closing, and hasn't gone through the evidence that the government has. And I think when one fairly looks at it grotesquely undermines the government's theory. They did have a lot of witnesses, and they told a very detailed story about their back and forth and where they went and what they did. But I think that the forensic evidence details something very different. And there's no getting around that reality. So,
I mean, just using the two pieces you just brought up, the boot seems, who cares? I just don't see what relevance it has. It didn't play any part in the Commonwealth's case, the boot. And we have all kinds of people stomping around the crime scene. And the fact that somebody is stealing stuff out of this house when you've got all these people wandering around it, how does that exonerate the defendant? I don't get it.
The government's theory was that Brunel picked up, Johnson and Norris and went over, and Norris went in, and it's described how the murder supposedly occurs, and that Norris is then at the scene, and he remains at the scene for some time, and that the other two come over, and that they, have an interchange with him.
I can't remember the other two gentlemen's name. They're all part of coterie of people. So
Right.
So we got four witnesses putting him,
putting him at the scene.
right.
And the defense does call witnesses that talk about the other people having drugs that, could have been tied the way that Chad tied drugs. And so they're there, and they have this, under the government's theory, they have this, we're going there to care for the situation and do right. And then there's even under the defense theory, there's as it exists, the trial transcript, they're there, and they're stealing from the place, would support Your Honor's view. And
And he's got it, Brunel has this weird scratch on his head. He's got a
Brunel
cut.
has this weird scratch on his head.
The defense counsel points out, right,
Points out,
right,
and I have the DNA testing of the,
have that Brunel is using drugs tied the way the victim tied drugs. So
Right.
he's done a fairly good job of shifting the blame to Brunel, hasn't he?
he has created a case, and what I'm saying, Your Honor, is that when you go back and that you look at the case, there is a far better way of doing things, and that the state of the law in 2019 and in 2000, when this case was tried, was that the forensic evidence has to be looked at, and that it has to link, all link together. He probably also, or one also would say that these were, these were not angels. They're all drug addicts, and it's a collection of misfits. And Johnson is, he's testifying with the hopes of a courtesy. And I think the government's view is this very logical way of how this crime occurs, and that when you look at the physical evidence, it's inconsistent with that, and that the jury would have, if the jury was told about the Bureau and that it's being gone through, and that something is being stolen, and it looks, the fair and reasonable inference is it's stolen quickly, that the jury would have considered that. They would have had to, because the version the government has is that Norris is there for hours, and that he's wearing gloves. It's just, respectfully, it's wholly inconsistent with their theory. And the footprint it's probably their strongest piece of evidence tying Mr. Norris to the crime, because it's located, a similar print is located outside his house. And it is, according to the testimony of the expert, it is different from the prints that are at the scene. There are also several other individuals, other prints that aren't identified that are there. Now, they could be Norris's, they could be Johnson's, and I think one set that's just not identified at all who it is.
The other two gentlemen are in the house as well, right? Varner, I can't remember their names. The other two, the people who
Yes.
are looking for looking for the victim, because they're worried that he's dead,
They all go
around the house.
tromping through the house. And, that's the testimony, and the physical evidence largely is consistent. And so I think there is an obligation to to look at the evidence and to, analyze it before coming up with a defense theory. And that's in essence the claim. The one other issue that was, well, I'll stop there.
Okay,
Thank you very much.
Mr. Calaflores? It's afternoon.
Afternoon, and may it
Barely.
please. Barely. Good afternoon, and may it please the court, Joseph Calaflores for the Commonwealth. The Commonwealth would ask you to affirm this conviction. When we're looking at the claims of ineffective assistance of counsel, there's numerous mentions of footprints, fingernails, drug connections in New York. A lot of these are non-prejudicial to the defendant, and I want to focus in on the drug connections in New York and who the proper third-party defense person would be. At trial, the defendant put forward that it was Brunel and Johnson that kind of concocted this whole scheme to frame him. And that was well presented at trial. We're looking at Brunel. Justice Caffrey mentioned the scar, the scratch on his face that was not present earlier in the evening. Additional and ancillary to that was that he had drugs on him that were tied in a certain fashion that were more familiar with the victim. It was drugs that could have been found at the house. So the idea that Brunel did this to either, for whatever reason, to get back at the drug dealer or what have you, was well presented, and the jury well put that off. When we pull back from all these little claims of ineffective assistance of counsel and we look at the case as a whole, it was logically well presented. We have Brunel showing up. He's getting called to the defendant's grandmother's house. They pick him up, the defendant. They then go and pick up Johnson, and then they proceed to 81 Brickett. Brunel passes over some gloves. He tries to extricate himself, but he does see the struggle at the door. And so when the defense is now saying that there's minimal evidence, and one of the claims is the sufficiency, and that it doesn't really point to a single element that is kind of lacking throughout this whole trial. It's really built on the testimony of the four witnesses. You have Brunel, you have Johnson, you have Varner and Freeman that confirm it when Brunel tells them, and they later return to the scene, and they see the defendant there who shoos them off, but they return and still enter into 81 Brickett. And then most importantly, I think that not a lot of mention has been given to it, is that the defendant then admits to Bernard Williams later the next day. He said, I did it. And that kind of dovetails into the question of whether or not the judge properly reviewed the two allegations that the Commonwealth did not, that they suppressed two draft letters that were given to Detective O'Connor. And I would point the court to transcript volume 333 to 39, where Judge Page at trial gave lengthy findings after an evidentiary hearing from Pearl Johnson and also regarding the Williams statement. So there's two letters. One was a handwritten draft statement, which Detective O'Connor said he does not give paper and pen to provide draft statements. And the judge properly discredited that one as existing. The second statement was
Johnson's statement never existed is the finding?
Yes. So the Williams statement is the second one, which is he initially denies it. The detective starts typing it up, and then there's a question, well, what if I'm lying? What happens? What happens from here? And the detective tells him, and then the draft is redone. It is edited, and there's minimal substantive changes except for the end, where instead of saying they had a few beers, it says that the defendant told him, which may be the real substantive part of the statement.
That's not minimal.
As a totality of the number of words written. And when we're looking at that, the judge properly weighed the culpability of the Commonwealth in not preserving that initial draft to the final drafts, the final statement. So the trial judge properly gave a remedy to the defendant to cross-examine the witness about this draft, and the defendant took that opportunity and did so. So when we're looking at it, that really is there's no real particular sufficiency claim. The trial judge did not abuse her discretion as far as the letters. And all of these, kind of being a little circuitous here, but going back to the ineffective claims of these little moments of impeachment, they don't add up to much. It's a little bit here, a little bit there. What time was the San Antonio Spurs playing to? At what time did the third quarter end? How exact is Brunel in saying, I got a call at this time and it took me exactly 20 minutes to get there, and then we went to just shy of 81 Brickett, picked somebody up and went to Brickett. The only hardened time frame is that sometime around midnight, at the second motion for new trial evidentiary hearing, the officer testified that they went at midnight, around midnight, and saw nothing, and then returned at 3 a.m. All of this general time frame matches from witness to witness, from the arrival at the grandmother's house, to the arrival at 81 Brickett, to the leaving, to the moment where Johnson leaves and goes back to his mother's home, and the defendant shows up with the Subaru. It is all in a loosely fitting time frame. And to say that somebody else could not get into this house within the 12 o'clock and 3 o'clock hours to rummage through, these were known drug dealers, so it's not to say that someone else might have come through. All of this doesn't really add up to any real prejudice, because it doesn't take away from the fact that you have Brunel and Johnson observing the murder. Johnson, he describes it as arm movements, repeated arm movements. And the victim did receive 39 stab wounds all over the body, the front, the back, each thigh. It was a scene. And none of these really prejudice the defendant as far as that time frame.
If I could go to the San Antonio Spurs game, what's in the record with regard to it? Does the record indicate who the Spurs were playing?
I do not believe that Johnson actually testifies who they are playing. His testimony is that it is a double-headed game, and that they were the latter game, and that it was in the third quarter approaching the end.
Okay, and do we know is there any evidence from TV as to what was happening on that day, or is it just some claim that the Spurs would not be playing?
Attached to an affidavit in the second motion for new trial was, I'm not entirely sure of the source of the printout, but it says that the game started at 9:30, and it may have been an LA team. Clippers, Lakers, I'm not positive.
Consistent with apparently the prosecution claims it's about 11:10. If it's a West Coast game starting at 9:30,
yes,
that seems about right, actually.
It sounds about right, but when we start honing in on the impeachment of this witness, is that he couldn't have been there because the third quarter specifically mentioned and referenced prevented him from being on site. And there's nothing to support that the third quarter was at that time, or that the quarters went lengthy. It's not a game that has a continuous clock. It stops and goes and then throws it.
Judicial notice of that. But the Commonwealth's claim was that that Johnson was there at or about 11:10 p.m., I gather.
Approximately, yes.
So the impeachment would have to be that if he said he left at the third quarter, that couldn't possibly be at or around 11:10 p.m.
Yes.
Okay.
And very briefly, the last issue I'd like to briefly address is the trial judge's decision to not recuse herself. The trial judge represented the witness's sister in a 1985 drug case, and she brought it up to the parties' attentions herself, gave the parties a moment of reflection, and both parties declined to lodge any objection to that. And under the standards looking at an abuse of discretion, it is clear that she did not, after consulting her own conscience and everything, and she announced that, she emphasized that the passage of time really precludes this from being issued to the relevant case in 2001. There are no further questions. The Commonwealth would rest on its brief.
Okay, thank you.